Hello friends, welcome you all to Success Seeker. Friends, as UPSC exam is approaching and current affairs plays a very vital role in prelims and mains examinations. We have already seen that. And Vision IAS PT365 is one of the best material to stick in. And if you are not so thorough with the monthly magazine throughout the year, and if done also, then also you must go through this for revision purpose, which will make your preparation more concrete. So I thought to go through this material for you all experience in a quick revision format and cover the parts which are most relevant for UPSC. Also note that this all PTs of different subjects may go up to many videos part by part. So kindly subscribe my channel and press the notification bell so that you can get the notification as soon as I upload it. And this will cover all PTs positively. So friends, don't forget to like if you really do it and support me. So let's start. First of all, let's check the content of the Vision IAS material. तो पहले देख लेते हैं हम लोग, and this is for polity and governance which they have uploaded first. First is issue related to constitution, number 1. Number 2 is functioning of parliament, state legislature, local government. Number 3 is center state relation, very important. Number 4, judiciary. Number 5 is elections. Number 6 is important legislation or bills, is very important for your examinations. Number 7 is constitutional or statutory or executive bodies in use. This you have already done in polity. Here we will see some more extra information if they have covered. Number 8 is important aspect of governance. So first is a very important topic and a very recurring topic, and I hope you all must know this topic very well. That is basic structure doctrine. So basic structure doctrine, we all know that it is related to Keshwaranand Bharati case, that is 1973, famous judgment case, and it was related to violation of fundamental rights under Article 25, 26, 31. 31 right is right to property, which was given legal right under Article 300A. So basic structure doctrine, what was the evolution of the doctrine, why it was needed, I hope you all know that very well. Still we can revise it here. It started from A.K. Gopalan case, that it was in 1950. Then 1951 Shankari Prasad case, 1965 Sajjan Singh case, 1967 Golaknath case, 1971 two famous amendments, that is 24th, 25th amendment, and finally 1973 Keshwaranand Bharati case of Kerala. Actually it was Kerala Land Reform Act, which was against this act, as it was violating the fundamental rights. So question may arise from here that they can ask different case related, is it related to basic doctrine structure or not. So these cases you must know, and the amendments, that is 24th and 25th. In 24th it was written that constitutional amendment is not law under Article 13, so Parliament can amend it. So 24th amendment, constitutional amendment, Parliament can amend the Article 13 amendments. and in 25th it was curtailed. Right to property with due compensation, and the precedence of DPSP over fundamental rights. We have seen that conflict was between which is more higher, or which is more important, DPSP or fundamental rights. So there was always a conflict. So in 25th amendment also a precedence of DPSP over fundamental. So DPSP got the precedence. Next, it took away the scope of judicial review. So judicial review for Article 39B and 39C, it was taken away. So finally, 25th Amendment was done. And in 1971 also Article 368 did not confer amending power to Parliament. In 1971 fundamental rights of citizens are limited. Parliament can amend any part of the. So here mainly it was a conflict was there between the Parliament and the judiciary. So means who is more supreme, or who can amend the article anytime. There was a conflict between these two. So we have seen in different cases that in different cases the Parliament can amend. Here you can see that Parliament can amend any part including fundamental right. So हम लोग ने देखा कि हर एक बार यहाँ पे कॉन्फ्लिक्ट आ जाता है कि कौन सुप्रीम है, पार्लियामेंट या जुडिशरी. तो यहाँ पे पार्लियामेंट को कभी ऊंचा दिखाएगा, कभी जुडिशरी को दिखाएगा. तो यहाँ पे लास्ट में केशवानंद भारती केस में बाद में बोला गया कि पार्लियामेंट कैन अमेंड एनी आर्टिकल बट बेसिक स्ट्रक्चर शुड बी contained in it. Means the Parliament cannot amend the basic structure. Now what is the basic structure? Basic structure are different basic amenities or basic requirement of the law which was formulated while formulating the Constitution of India. That is, you can take secularism, you can take different sovereignty. Here some principles are given here. You can see here sovereignty of India, mandate to build a welfare state, supremacy of the Constitution. You cannot take away the supremacy of the Constitution. Secular and federalism, separation of power, unity and integrity, power of judicial review. Judicial review power is very important. This also you cannot take away. The Parliament can make any law or amend any law, but they cannot take away this basic structure. This was the main fundamental judgment given by the Keshwananda Bharati case 1973. It was a 13 judge bench of Supreme Court. So finally the judgment came and the basic structure doctrine started from then and there also. That is in 1973. So this is all about basic structure. Here it is given independence of judiciary and district judiciary. So यहाँ पे डिस्ट्रिक्ट जुडिशरी के बारे में बोला गया है. तो हम लोग जानते हैं कि डिस्ट्रिक्ट जुडिशरी में दो टाइप का, हाई कोर्ट में दो टाइप में कोर्ट को डिवाइड किया गया. दैट इज़ डिस्ट्रिक्ट कोर्ट और सेशन जज कोर्ट. तो डिस्ट्रिक्ट कोर्ट में सिविल साइड में सबऑर्डिनेट जज कोर्ट और मुंसिफ कोर्ट आता है, और क्रिमिनल कोर्ट साइड में चीफ जुडिशियल मजिस्ट्रेट CJM और जुडिशियल मजिस्ट्रेट. सो यहाँ पे डिफरेंस जानने से आप लोग को यहाँ पे हो जाएगा. यहाँ पे बोला है कि सुप्रीम कोर्ट इन द ऑल इंडिया जज एसोसिएशन वर्सेस यूनियन ऑफ इंडिया केस स्टेटेड दैट द डिस्ट्रिक्ट जुडिशरी इंडिपेंडेंस इज पार्ट ऑफ बेसिक स्ट्रक्चर. So why basic structure is again in the news? Because here it is given in the case it is given that district judiciary is also independence is also a part of a basic structure. So you cannot take away or give away the powers or take away the powers of the district judiciary. It also highlighted other terms, that is integration in terms of pay, pension and other service connection between district judiciary, high courts and Supreme Court. Separation of power. Officers of the judiciary should be treated separately from staff of legislative and executive wings. Unified judiciaries. Service condition of judges for similar posts are equivalent across states. So here actually it is telling about the judiciary, means the district judiciary is also a structure of basic structure and you cannot take away some rights from them. Next is abrogation of 360. So this was also in news this year, that is 360 is already abolished in 2019. You all know that is on 5th August. The date is very important, you must know. So on August 5th 2019 article 360 was abolished, but a case was also taken by Supreme Court regarding the abrogation of article 360. So here Supreme Court also said that it validated the abrogation of 360. So 360 is right according to Supreme Court. And decision to repeal special status to Jammu and Kashmir under article of the Constitution of India was before 2019. It was there that Jammu and Kashmir was given a special status under article 360. So now it is no more. So from here you can see the important thing is what was the act which was there to formulate the abolition of 360, that was Constitution application to Jammu and Kashmir order 2019. This was the act which was passed to do this matter. Or Jammu and Parliament also enacted Jammu and Kashmir Reorganization Act 2019, which bifurcated the states into two union territories. So now Jammu and Kashmir is divided into two states, two union territories, that is Jammu and Kashmir and Ladakh. So two union territories is there now. So what the judgment said, it uphold the presidential proclamation of article August 2019. So president proclaimed this, you all know that, the abrogation of 360. So now judgment also upholded that presidential proclamation. Supreme Court held that Jammu and Kashmir did not retain any element of sovereignty after it acceded to India in 1947. And Supreme Court held that Article 360 is a temporary transition permit. So Article 370 was temporary, we all know that, so it can be abrogated. So this was the judgment given by Supreme Court. Next we can see that the court held that UTs can be carved out of a state. So how you can see by this, if you have seen the Constitution, that is article 3, that is the word state, or in article 3 only it is written that the state can be formed out of the other state if it gets the parliament, if pass the resolution, or parliament if pass the law. So here also one important case here it is referring, that is SR Bomai case. SR Bomai case was regarding it was held that action of president during a state emergency was open to judicial review. And you have to know that SR Bomai case was regarding judicial review. So president order can also be under judicial review. This is the main funda or main material of SR Bomai case. Next is given the historical context. I think you all know that in 1947 Maharaja Hari Singh, he was the ruler of Jammu and Kashmir, and he signed instrument of accession and acceded his state to the dominion of India. From there onwards, Article 370 was placed under temporary provision, and 35A, this also was an important article where the resident of that state have got the right to settle there, and other state resident cannot go and settle in Jammu and Kashmir. So this was Article 35A. So Article 3 also you can, so Article 3 becomes important from this perspective. You have to know it very well. Next is regarding National Capital Territory of Delhi. So NCT amendment. So this was amended in 2023. So this also becomes important. So National Capital Territory, you all know that Delhi is a union territory, but it has its constituent assembly, and Chief Minister of Delhi is the chairperson of National Capital Territory of Delhi State Statutory Authority. Here it is given, National Capital Civil Service Authority, to make recommendation to recommendation to Lieutenant Governor regarding transfer, posting, vigilance, and other incidental matters. So NCSA shall be decided matters by the majority of votes of the member present and voting. Central government will appoint both the principal secretary and chief secretary. So here it is actually here it is given the National Capital Civil Service Authority that is present there. In exam it may come the composition. Here Chief Minister of Delhi is the chairperson, Principal Home Secretary of Delhi government is the member secretary, and Chief Secretary of Delhi government is the member of this authority. And Lieutenant Governor is present there. He only gives the recommendation regarding posting, vigilance, and other incidental matters. So this is not so important according to my view. So you can have a look at this. Next is the governance model of Delhi NCT, how it is modeled. You can have a watch. Evolution of administration of Delhi government, that is how the Delhi government was formed. This date you have to know. 1952, that is Legislative Assembly was created with elected Chief Minister. So Chief Minister was created in 1952. Delhi was made a Part C state in 1951, but in 1952 they got the Legislative Assembly with elected Chief Minister. And under State Reorganization Act, under Act Delhi became a UT in 1956. So in 1956 Delhi became a UT. So next date is 1966, where Delhi administration provided a limited representative government in Delhi. So 1951 Part C state, 1952 Legislative Assembly was created, 1956 Delhi was made a UT, 1966 limited government was formed. And next comes the important amendment, that is 69th Constitutional Amendment Act, which was passed in 1991, and Delhi was given a representative government and its administrator. GNC TD Act was passed in 1991. So this act only 2021 Amendment Act was passed for this act. So next important thing which you need to know, that is governance model of NCT, Delhi NCT. So it was formed under State Reorganization Act 1956, Delhi was classified as UT and governed under Article 239. Very important. Under Article 231, 239, it is governed. 239, and it is directly governed by the president or an administrator appointed by the president. Special status for Delhi was based on the recommendation of S. Balakrishna Committee. Very important. S. Balakrishna Committee. The 69th Constitutional Amendment was passed on his recommendation, that was in 1991, and special status on Delhi was designated as NCTD of Delhi. So this act was passed in 1991, where special status was given to Delhi under recommendation of S. Balakrishna Committee. Very, very important. It added 239 AA to the constitution and made Delhi a UT with the legislature and a council of ministers. So minister will be a council of minister also is there, and administrator is also there. So they functions differently. The function is different for the council of ministers and the administrator. So Article 239 AA and 239, Article 239, these two articles are important. Lieutenant Governor is designated as the administrator of the Delhi, operating with the aid and advice of the Council of Ministers. Very, very important. Aid and advice of the Council of Minister of Delhi. So, Lieutenant Governor must consult with the Council of Minister of Delhi for any administrative purposes. Powers of Delhi legislature. The Delhi Legislative Assembly has the power to legislate over subjects in the state list and concurrent list, except for police, public order and land. Very, very important. So, three things which they cannot touch, that is the Legislative Assembly, that is police, public order and land. This is to the central government. This power is given to central government, and rest, the state list and the concurrent list, these two list powers are given to Legislative Assembly, Delhi Legislative Assembly, the DLA. Also, Parliament can legislate over all matters in the state and concurrent list related to Delhi. So here something is colliding also, means some on all matters in state and list, concurrent list for Delhi, Parliament can also legislate. So here Delhi Legislative can also has got the power to legislate, and the Parliament has also got the powers, except police, public order and land. So now this act is on a verge to amendments. So this is all regarding Delhi Assembly and its union territories. Next important thing is preventive detention. So preventive detention you have already studied in polity. So that is if a person without trial and conviction by a court or a mere reasonable apprehension of him doing any activity dangerous to public, means a person is without any trial, he is under custody, since it is means if the police finds him that he may do some danger to public, so then only without trial also he can be put behind bars. So this is preventive detention case. Its purpose is to prevent the person from committing any offence in the near future. Protection against arrest and detention under Article 22(1) and 22(2) is not available to the person arrested or detained under. So preventive detention persons are they are void or they cannot enjoy Article 22(1) and 22(2), that is arrest and detention case. Parliament has exclusive authority to make a law of preventive detention for reason connecting with the defense, foreign affairs and security of law. Very, very important. This is very, very important. So, matters related to defense, foreign affairs and security of India, if these three matter is under concern, then a parliament can have exclusive authority to make a law of preventive detention. So parliament can make law regarding preventive detention and a person can be detained without any trial. So both parliament as well as state legislature can concurrently make a law for reason connecting with the security of law, maintenance of public order and maintenance of supplies and services. Multiple laws such as Code of CPC, Narcotic Drugs Law 1995, UAPA, that is Unlawful Activity Prevention Act, etc., permit preventive detention. So this these laws, they permit preventive detention. This case related is related to public order and security of India. So this under these acts, person can be detained without any trial. So here constitutional provisions related to preventive detention is given. This is actually polity you have studied in Lakshmikant book. Article 22(1), that is no person can be detained in custody without being informed of grounds of arrest. Article 22(2), every person who is arrested, detained shall be produced before magistrate within 24 hours. And you have to remember that this is except the travelling hours. Article 22(3), above two clauses will not apply to a person who is detained in accordance to a law providing for preventive detention. 22(4), no person can be detained for more than a period of 3 months. More than 3 months you cannot detain unless an advisory board confirms that there is a sufficient cause for detention. So these acts are important, you need to know. Next, some case also is related to this act, that is A.K. Gopalan versus State of Madras 1950. The court gave a green flag to preventive detention 1950. So this was adopted in Gopalan case. Next is Siban Lal versus State of Uttar Pradesh. Supreme Court stated that a courtroom is not competent to inquire into reality or in any case of the fact which are referred as grounds of detainment. Next is Sambhunath Shankar versus State of West Bengal, where court held sometimes state must take some extreme steps to maintain security of. So these three cases are related to preventive detention, and this supports preventive detention. Next is Article 22(7), also you need to see, that is a person can be preventively detained for more than 3 months without opinion of any advisory board if parliament by law provides maximum period of such detention. Circumstances classes of means here parliament is superior to advisory board, means without advisory board's commitment confirmation also you can detain if parliament makes a law, means how much time it can be detained. So these are the different laws regarding preventive detention, you need to know, very, very important. Next is personality rights. Recently Delhi High Courts granted protection to famous Bollywood actors personality rights from misuse by third parties. So here it is related to some rights which Delhi High Court given to Bollywood actors. Personality rights like it includes name, voice, signature, images or any other features which actually hampers identity of a person. Personality rights in India or their protection are not expressly mentioned in any statute of India, but are traced to fall under the right to privacy and property. So personality rights is related to right to privacy and property. This may be a question. Next is two components of personality rights: right to publicity, right to privacy. So right to Trademark Acts 1999 and Copyright Act 1957, these are the publicity rights you need to know. And right to privacy, this famous case, that is case Puttaswamy case 2018, where article 21 was stretched. So this is regarding personality rights, which you can see very in fast manner. Next is posthumous personality rights, emblem and names. These are some acts which are given, not so important. TRIPS agreement, WIPO, these all are related to personality rights. They are referring it. Next is constitutional provision related to personality rights, that is article number 21, which states that no person shall be deprived of his life or personal liberty, and article 300A, that is right to property, which was amended by amendment 44 by amending 44 Amendment Act 1978. It was the right to property was taken to article 300A. Some cases here it is given: Deepa Jayakumar versus L. Vijay Kumar, Shakshi Malik versus Venkatesh Vada Creation Private Limited. Next topic is hate speech. This hate speech topics reoccurs almost every year. So hate speech, you all know that some speech which are related to a hate or it may cause crime, that is related to hate speech. It may hampers some personality and create a crime in the public, and public gets harassed by it. So this is hate speech. Hate speech can be conveyed through any form of expression, including images, cartoon, memes, objects, gesture and symbols, and it can be disseminated offline or online. So here may be one of the question, that hate speech can be only in offline, but it is not the case. It is online and offline, both it may be the case. That is primarily against a group of persons. So here hatred primarily against a group of person. Regulation of regulation of hate speech in India, that is constitutional provisions, is article 19(2) on the grounds of public order, incitement offence and security of India. Three grounds under which hate speech can be curtailed, that is under article 19(2) on grounds of public order, incitement of offence and security of India. Next comes Bharatiya Nyaya Sanhita, that is 2023. There's some names was amended or rectified. Section 1920 penalizes promoting enmity between different groups on grounds of religion, race. Section 299 defines punishment for deliberating and malicious act. Next is section 353 1 and 2 penalizes the publication or circulation of any statement, remarks or report causing public mischief and enmity. Means here the criteria are given in different sections what may be the cause for the hate speech. Next is under Representation of People's Act 1951, that is RPA Act 1951. Section 8 disqualifies a person from contesting an election. So election may be curtailed for the candidates if he is under hate speech, a charge under hate speech. Next is section 123 3A and section 125 prohibits the promotion of enmity on grounds of religion, race, caste, community or language in connection with election as a corrupt electoral practices. So in election also you are barred if you are convicted of hate speech. So judicial pronouncement related to hate speech, that is different case. You can know this: Pravasi Bhalai Sangathan versus Union of India 2014. Shreya Singhal, very important. Shreya Singhal case 2015 on hate speech. Next is Amish Devgan versus Union of India 2020. This is also related to hate speech. Next is Protection of Civil Rights Act 1955. Section 7 penalizes incitement of. So different sections which are related to hate speech means through which you can be punished. Religious Institution Prevention of Misuse Act 1988, Section 3G. So this section I don't think it is very much important, but you can stretch on if hate speech is given, what are the constitutional provisions and through which act you are, where you are disqualified, and different cases which are related to it. That is 3 cases here is given. Most important is Shreya Singhal versus Union of India, that is in 2015, related to hate speech. Next is Places of Worship Act 1991. What is this act related to? The Supreme Court observes that it cannot order a blanket stay on order worship act, please. About places of worship, special provision 1991. Supreme Court observed that it cannot order a blanket stay on worship act, means where to worship and how to worship. Supreme Court actually it is giving its order. About places of worship, Act declares that the religion character of a place of worship shall continue to be the same as it was on August 15, 1947. So it got back to 1947 where it was the place of worship, religious character, it has to be same. This is how Supreme Court is defining. It says no person shall convert any place of worship of any religious denomination into one of the different denominations. So from then onwards, if a place of worship is of different of one religion, it cannot change afterwards the same place. Exemption provided is the disputed site at Ayodhya is exempted from the act, since it was a different case where Babri Masjid was it was a conflict area. So after that it got that Ayodhya Hindu, it was a Hindu Ram Janmabhoomi. So Ayodhya case was owned by the Hindus. Actually it was given to both the Hindus and Muslims. For Muslims different place was given, and for Hindu it was given different place. Next is monuments and sites covering by the ancient monument and architectural archaeological sites and remains, Act of 1958. Any disputes that has finally settled or dispute of. So these are exemption which are related to this. Penalty is Section 6 of the Act specifies a punishment of maximum of 3 years imprisonment along with a fine if you have done this. So this is related to places of worship. Means Supreme Court said that you cannot change the place of worship, you cannot change the religion of the same place differently. Next is other important news which are related is 8th schedule of constitution. Odisha cabinet has proposed for the inclusion of Kui language in the 8th schedule. So Kui language is related to Odisha and they are demanding it to place in 8th schedule. In 8th schedule we know that we have 22 languages currently. 14 languages are originally, but later it was Sindhi, Konkani, Manipur, Nepali, Santali, Dogri, Maithili and Bodo was included. Next is 9th schedule of the constitution. You know that it added the constitution by first constitutional amendment under article 31B. Central and state laws including 9th schedule cannot be challenged in court for the violation of fundamental rights. So this 9th schedule case was there where IR Kohelu case versus State of Tamil Nadu 2007 was held, where it was challenged and violating fundamental rights can be challenged. It undermined the basic structure as outlined in Article 21 along with Article 14 and 19. Any law added to that after violating fundamental can be challenged. Means IR Kohelu case, after that it said that basic structure doctrine must prevail. This is the main funda for 9th schedule. Next is right to silence is one of the right. Here it is discussed. Right to silence emanates from Article 23, 20 under 3. Nandini Satpathy versus PL Dani case. You can remember this. Reservation for locals in private sectors. Here one more means issue was launched. Issue was there that for in the private sector locals must be reserved. In Punjab and Haryana it was given 75% reservation for in the private sector jobs. Not much important. Next is Ranganath Mitra Commission, one important commission. It was formulated. It was officially known as National Commission for Religious and Linguistic Minorities. It was constituted to look into the various issues related to linguistic and religious minorities in the country. Report by 2007 recommended that scheduled class status be completely delinked from religion and made religion neutral like ST. It had recommended permitting Dalits who convert to Islam and Christianity to avail scheduled caste status. So different views it was placed by this commission. It was mainly regarding religion and linguistic minorities. You must know this. Next is Article 355. It is a part of emergency provision. You know that right to work. This is one more right that Punjab has become the first state to implement the right to work. Important. Right to work may make it mandatory for all road owing agencies, including the NHAI, to provide footpaths and cycle tracks on the road. So, right to work. Punjab, first state to implement this. So, we have covered this first part.